Hi friends, today I would like to discuss with you another significant topic of law called precedent or judge made law. We know that whenever the law is being passed by the legislature, that is called a statute, and when the judges of the Supreme Court or High Court they pass a judgment, that also become a law, that is called judgment or judge made law. It is also popularly known as a citation or precedence. Why do we follow the judgment or precedent of the Supreme Court or of the High Court? That there has to be uniformity in the judgments which are identical and similar. Otherwise, the number of court, if they don't follow the judgment of the Supreme Court or High Court, then there will be diversity. Therefore, we must respect the judgment of the Supreme Court and we must respect the judgment of the Honorable High Court if the case is identical and similar to the fact. The two conditions need to be satisfied when we are giving a citation, that the judgment must be identical and similar to the fact, and the same question of law must be involved there. The fact must be same, then and then that judgment would be considered. If the judgment is not identical, the citation which we are tendering is not identical or similar to the fact in a hand, case in a hand, then that judgment or citation cannot be considered by the court. Now we must know the difference between what is identical and similar. Identical means exactly same to same. The fact of the case must be same, the question of law must be same, and similar means having similar characteristics which resembles like that. So either the judgment must be identical or similar, then and then the judgment can be considered by the court. Now what is the law relating to this, that we would like to discuss one by one. As per Article 141 of the Constitution of India, the judgment delivered by the Honorable Supreme Court of India is binding on all the high courts in India and all tribunals in India and all the lower courts throughout the country. Once the judgment is passed by the Supreme Court, it becomes a law. As long as that judgment is overruled by the Honorable Supreme Court, that must be considered, and that is by virtue of the principle of stare decisis. Likewise, the judgment delivered by the Honorable High Court is binding on all the lower court or trial courts within that territory. For example, if the judgment is delivered by the Honorable High Court of Bombay by any of the benches, then that is binding on all the lower courts. The judgment delivered by the division bench of the High Court is binding on subsequent division bench. For example, the division bench of the Bombay Honorable High Court of Bombay has passed the order, then that in subsequent case the judgment would be binding on another justice whenever they are deciding the similar case subsequently or in future. The order of the division bench is also binding on the division bench subsequently deciding the case. Undoubtedly, the order passed by the division bench of the High Court is definitely binding on the single judge of the High Court and all lower courts within that. And order or judgment passed by a single judge of the Honorable High Court is binding on the single judge of the High Court in subsequent case, but the judgment delivered by the single judge of the High Court is not binding on the division bench of the High Court. Because why? The division bench is having more power, and whenever a division bench is sitting, that division bench may consider the judgment passed by the single judge in earlier case, and the division bench has power to disagree with it, because earlier judgment was delivered by the single judge, therefore it is not binding on the division bench, but it has to be considered. And judgment delivered by the another High Court of another state like Karnataka High Court is not binding on the High Court of Bombay or any other high courts. It does not have binding force, it has only persuasive value. Means it can be considered, but it is not having a binding force. Even the judgment delivered by the Karnataka High Court of 3 judges or 5 judges bench is not binding on the High Court of Bombay, because it is equivalent and it has only persuasive value and there is no binding force. It is not compulsory for the judges of the High Court of Bombay to consider the same. Similarly, undoubtedly the judgment of the high courts are binding on all the trial courts within that jurisdiction. Now, what are the parts of the judgment we would like to discuss here? The judgment has major parts, important part, significant part is ratio decidendi. The ratio decidendi, we know that the strength of the judgment lies in its reasoning. So the ratio laid down by the Honorable Supreme Court or High Court must be followed. That is principle involved in that. Substantial question of law is considered. Reasonings are given. That becomes the ratio decidendi. That is binding on the subsequent judges. Therefore, ratio decidendi is very significant and important. Whereas the obiter dicta or dictum means what? Whenever judges are passing the order, sometimes they pass a comment, what they feel, what they observe, but those comments are not having binding force. For example, one of the judge while passing an order in respect of case under section 376 of IPC, a lady judge has commented that मेरा बस चलता तो I would have given such a punishment to cut the private part of that accused. But there is no such a provision in the law. Those comments were only obiter dictum. Such a obiter dictum are not binding upon the subsequent court. Those are the only comments, by the way. Therefore, the obiter dictum are not binding at all. Only ratio decidendi, reasons laid down by the Honorable Supreme Court or High Court, and principle involved in that case, the reasoning provided by the judge, considering the law, considering the evidences, considering the earlier judgments, those reasoning, those ratio decidendi is applicable. That must be considered. And another principle of precedent I would like to mention here, without forgetting, the principle of stare decisis. The principle of stare decisis means once the judgment is passed by the High Court or Supreme Court, it is alive, it is binding. Therefore, it will be alive and binding unless and until the same is reversed by the higher authority or overruled by the higher authority. Or in case if the Honorable Supreme Court has passed a judgment, that will be applicable as per Article 141 of the Constitution of India. However, if that judgment is subsequently stayed by the larger bench of the Honorable Supreme Court of India or overruled by the Honorable Supreme Court of India, then the judgment comes to an end. So, unless the judgment is stayed or overruled by the higher authority or the same authority, that judgment is supposed to be alive. Therefore, it must be followed. That is the principle of stare decisis. Now, another concept of law is that regarding this judgment per incurium. We always hear about the judgment per incurium. Whenever a judgment is delivered by the court, Honorable High Court and Supreme Court, which is against the provision of law or against the landmark judgment of the Honorable High Court or Supreme Court, earlier judgment which was not considered at all, and the provision of the law is not considered at all, or the principles of some law like principle of natural justice etc. were not considered at all, then that judgment is called per incurium. And such a judgment which is per incurium need not be followed by anyone, even if the judgment is delivered by the Honorable Supreme Court of India, which is per incurium, that is, if it is against the specific provision of the law, or if it is against the earlier landmark judgment, or that earlier landmark judgment was not considered by